governor in the morning when he took plea, and he pleaded not guilty. Further charges include failing to submit annual reports and deliver an annual set of the county address to the county assembly for 2 consecutive years, and also by failing to appoint and obey court orders regarding the appointment of Clive Ogwara to the county executive committee. The governor is also accused of abuse of office. That is the second ground. Under this, the governor is accused of abuse of office by improper use of his authority in recruitment of staff without approved budget. The governor is also accused of influencing the appointment of Godfrey Kriago and Elmelda Nyaberi as Director of County Human Resource Management and Assistant Director Human Resource Management, respectively. Also that through personnel enrichment from receipt of irregular salary arrears amounting to 5.6 million Kenya shillings, and also abuse of office through systematic payroll fraud and syndicate, approximately 32 million shillings, and also abuse of office by influencing dual appointments outside the lawful establishment. Under the abuse of office, the governor is also facing a charge regarding usurpation of powers of the Auditor General and the County Public Service Board and violation of due process through illegal payroll, audit and demotions. These are some of the charges the governor is facing. However, in the morning, when the charges were read out to him by the clerk, both grounds the governor pleaded not guilty, and that set the pace for the preliminary hearings to begin, with the governor's side bringing up the preliminary objections regarding the threshold, on whether that particular threshold was met or warrants that particular motion. This is a matter that is coming up for ruling this afternoon. The Speaker indicated that he will be giving a ruling regarding the preliminary objections, as the governor's legal team is indicating that there is no clear threshold to give the motion some life for it to be able to proceed on to the next stage. The matter stems from the total number of members of County Assembly elected or represented in the County Assembly of Nyamira, as well as the number of the members who were present during the voting of the motion, vis-a-vis the number of members who supported that particular motion. Remember, 23 out of the 32 that were present voted to support that particular motion. However, the question that is coming up is whether the 2/3 threshold was met regarding the number of members, that is the total number of the County Assembly members or members of the County Assembly, and the ones that were present during the time that the motion was being moved at the County Assembly. If you're just joining us, is that the House is about to resume the hearing and determination on the proposed removal from office by impeachment of Honorable Amos Kimwoni Nyaribo, that is the governor of Nyamira County. He is facing an impeachment motion. And the Senate has that mandate as a quasi-judicial mandate. So the hearing has already begun. However, in the preliminary remarks, there were objections that were raised by the legal team from the governor's side, ones that were also dismissed by the legal team from the county assembly side. So the speaker is meant to make a ruling on that for the matter to be able to either continue or be terminated regarding on whether there is threshold for that motion to stand. So the members are already in the chamber. We are just waiting for the speaker to be able to make his way inside for the business to be able to continue. Remember, both sides are inside the chamber, that is the governor's side. The county assembly legal team include Katwa Kigen, Mokua Ndumi, as well as Doris Ngeno. And the governor's legal team include Elias Mutuma, Zelma Bonuke Omuira Temo, Brian Lee Orina, Erastus Orina, Sylvia Njoki, as well as Michelle McCanley. Once the ruling is made, that is in favor of the county assembly side for the motion to be able to continue in the House, then the county assembly will be able to give out evidence, to present its evidence before the Senate. This is a plenary sitting. The House is considering the matter in full House, in plenary, as opposed to a committee. That particular motion for the impeachment hearing to be done, the committee way flopped last week in the chamber, and the members of the Senate adopted the plenary way to hear and determine on this particular matter. So this is a full House. All senators are able to follow on the presentations from both sides, that is the county assembly, that are making their case. They will be able to present all the evidence that they deem fit to be able to make their case concrete. The governor's side will also be able to give their presentations to be able to counter any accusations that the governor is facing or that the county assembly will present. At this point, if there are any witnesses, any affidavits that were sworn, any audio that is to be played, any video that is to be played, any witnesses that are to be called upon to give their testimony, that is the presentation of evidence that will be done by either side in a way that to ensure that each side is able to defend its position. By all means, we will also see the cross-examination of the witnesses, as well as a re-examination of the witnesses, that is from both sides of the legal team. That is the next process that will be following at the time the ruling that is made by the Speaker, if either the motion will be upheld to be able to proceed or to move on to the next stage. That is all to be made clear to be able to enlighten on the position that the House has taken regarding this particular matter. This is the impeachment process, the hearing and determination of the proposed removal from office by way of impeachment of the Governor of Nyamira, that is Honorable Amos Kimomi Nyeribo, after 23 of the MCAs in the County Assembly supported this particular motion and forwarded the motion to the Senate to be able to consider the allegations or the charges that the members of the County Assembly leveled against the Governor regarding what they termed as abuse of office, as well as gross violation of the constitutions or other articles of the Constitution of Kenya. Earlier in the morning, after the charges were read to the Governor to take plea, the Governor pleaded not guilty. So it will be upon both sides, majorly the accusers, that is the side of the County Assembly, to be able to have very tangible and valid evidence to ensure that the charges that they have leveled against the Governor are proven beyond reasonable doubt that the Governor should be impeached or removed from office by way of impeachment. We are just waiting for the Speaker's procession to be able to make its way into the chamber to enable the House commence this particular business. However, remember, this particular day has been set aside and gazetted for the Senate to be able to hear and determine the removal from office by impeachment of the Governor of Nyamira County. The Governor is facing allegations regarding gross violation of the Constitution of Kenya, as well as the County Governments Act 2012, on a myriad of issues. Appointments that the county assemblies, or other county assembly says, were done outside the law, majorly not involving the county assemblies. One of them regards the approval or assenting to the County Supplementary Appropriation Bill 2024 without the approval of the County Assembly. This may have emanated as well from the accusation that the Governor allowed deliberations of formal engagements and endorsements, as well as support of unlawful, illegal and unconstitutional formation of the Bunge Mashinani. This is the assembly meeting, county assembly meeting, that was done away from the designated county assembly chambers. Remember, the county has been running on parallel county assemblies until a time when the committee intervened on this particular matter, and during that time, that is when some of the laws were passed or considered, as well as some of the appointments that the Governor is now being accused of having done them outside the law were done. Also, the appointment and selection of a panel for recruitment of the chairperson, secretary and members of the Nyamira County Public Service Board without the approval of the county assembly. Some of the articles that the governor is accused of violating: the Article 10 of the Constitution of National Values and Principles of Governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Article 73 and 74 of the Constitution of Kenya outlines the responsibilities of state officers and the principle of public service, demanding objectivity, impartiality, and accountability. And also Article 232, Subarticle 1 of the Constitution sets the values and principles of public service, requiring efficient use of resources, transparency, and fair competition and merit. Under these articles, the governor is accused to have appointed a selection panel for the recruitment of the chairperson, secretary, and members of the Nyamira County Public Service Board without the approval of the County Assembly of Nyamira, and that the governor willfully circumvented the legitimate constitutional approval process, rendering the appointment unlawful, and also that the selection panel proceeded to invite, also shortlist, and conduct interviews for applicants for the positions of chairperson, secretary, and members of the Nyamira County Public Service Board in total defiance of clear judicial and senatorial pronouncements, and also that these actions then are contrary to constitutional principles and undermines public service integrity. So in their submissions, the County Assembly has pointed out on a number of articles of the Constitution of Kenya that, as they accuse the governor of gross violation of the Constitution of Kenya, have highlighted various articles to be able to back their accusations up. The Senate is about to resume its sitting this afternoon. This day is allocated for hearing and determination of the proposed removal from office by way of impeachment of the governor of Nyamira County, Honorable Amos Nyaribo, facing a number of allegations, two grounds. One that being that of abuse of office, and the second one regarding gross violation of the Constitution of Kenya. However, these allegations, after they had been read out to the governor this morning, who took the stand to take a plea, pleaded not guilty. Now this renders the matter in the hands of the legal teams of both sides, that is the governor's side and the county assembly members' side, to be able to give a clear picture on why the governor should be impeached or why the governor should not be removed from office by way of impeachment. Just to remind you, is that there were preliminary objections that were raised by the governor's legal team on the threshold, indicating that the matter is lifeless and should not in any case proceed to the next stage, raising a number of issues, one being the 2/3 threshold, and also another issue rose from the voting by proxy on whether the County Governments Act allows that. So those are issues that, as the governor's legal team gave out their preliminary remarks, also brought up some objections on that whole motion, indicating that it does not hold water and that it should not in the first place even move to the next stage. But their words or their position was quickly countered by the legal team from the county assembly, indicating that in fact the matter or the motion met all the requirements and the threshold, and that it should not be dismissed at this point but move to its logical conclusion for the evidence also to be presented. The Speaker should be coming to give a ruling on that, as he had directed before the House went on a lunch break. And now that the members are back, the Speaker is also expected to make his way into the chamber first to give a ruling on these particular preliminary objections that will give an understanding on where this particular matter stands, whether it will continue or the ruling will be in favor of the governor. Said that is to be made clear when the Speaker makes his ruling. But this is the resumption of the hearing and determination on the proposed removal from office by impeachment of the governor of Nyamira County, a matter that began this morning. The members of the Senate being a full house, this matter is being considered at the plenary. Senate standing orders allows that such a matter could be considered by way of committee or plenary, that is full house when all the members are inside the chambers, or by way of committee. However, there was such a motion that was moved in the House last week for the matter to be considered by an 11-member committee. However, that matter flopped, rendering the motion to be considered by the whole House, that is by the full House of the Senate, each senator being able to follow up on the presentations and submissions that the two parties are presenting for this, or rather regarding this matter. But remember, if the Speaker rules in favor of the County Assembly, that is for the matter to be able to continue, or the motion to be able to continue, then both sides will have an opportunity to bring on board their evidence, especially the accusers of the governor's conduct will be required to present evidence, either by witnesses who will take the stand and take an oath that whatever it is that they are presenting before the House is nothing but the truth. Also, if there is any video or if there is any audio or if documents that the members of County Assembly deem fit for it to be presented as evidence or submitted as evidence that would support the charges that they have leveled against the governor, then that particular moment will come by. But if the Speaker rules in favor of the governor's legal team that say that the matter or the motion does not hold water, then that would mean perhaps that matter is rested. We shall continue to take a look at some of the allegations the governor is facing this afternoon. Remember, in the morning sitting, he took plea and pleaded not guilty. So all that will be made clear as the proceedings go on. The governor is accused also of abuse of office by improper use of his authority in recruitment of staff without approved budget. Some of the articles that the members of the County Assembly indicate were violated include Article 10 of the Constitution on national values, Article 73, 74 and 75 on the responsibilities of state officers and the principles of public service, as well as Articles 201 subarticle A, D and E of the Constitution of Kenya, regarding openness and accountability, including public participation in financial matters, that public money shall be used in a prudent and responsible way. E indicates that financial management shall be responsible and fiscal reporting shall be clear. The County Assembly indicates that the governor presided over and influenced the approval of recruitment of staff without an approved budget. They have attached County Executive Committee minutes that were recorded on the 26th of February 2021, of course in his response to an inquiry from the Controller of Budget, that the recruitment approved by the County Executive with full knowledge that there was no budgetary provision for that particular recruitment to be able to take place. Under the abuse of office, the governor is as well accused of personal enrichment from receipt of irregular salary arrears amounting to 5.6 million Kenya shillings. The Constitution indicates that there shall be openness and accountability, including public participation in financial matters. Public money shall be used in a prudent and responsible way, that financial management shall be responsible and fiscal reporting shall be clear. And whereas Article 234A of the Constitution of Kenya mandates the Salaries and Remuneration Commission to set and regularly review the remuneration and benefits of all state officers, as well as Section 97 of the Public Finance Management Act requires public funds to be used in accordance with the law and for the purpose for which they were appropriated. Also, Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. The members of the County Assembly indicate that in September 2021, through the facilitation of two cherry-picked officers, that is Mr. Godfrey Kiriago, the Director Human Resource, and Imelda Nyaberi, the Payroll Manager, the governor conferred upon himself an irregular salary payment christened as arrears and amounting to 5.6 million Kenya shillings. The MCAs also further indicate that there were no outstanding arrears due to the governor since his assumption to office had neither was he owed any arrears as a deputy governor. These are some of the accusations that the governor is facing this afternoon, matters that have made their way to the Senate. And this afternoon, the business or the procedure in the hearing and determination continues. The Speaker of the Senate, Honorable Amason Jeffa King, is in the chamber to resume this debate. Allow me to hand you over to the proceedings.
Na tuombe. Mwenyezi Mungu, twakusihi ututazame kwa neema nyingi na baraka sisi watumishi wako ambao umeridhika kutuita kwa nyadhifa za uongozi katika jamhuri hii yetu. Twakuomba utuwajalie tuyatende na kufikia mambo yote atakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen. So, Clerk, do you have quorum? We do have quorum. You may proceed to call the first order for the afternoon.
Order number 1, communication from the chair.
Now, honorable senators, ladies and gentlemen, as you will recall, at the commencement of the hearing of the proposed removal from office by impeachment of Honorable Amos Kimwumi Nyaribo, the Governor of Nyamira County, earlier today, Wednesday, 3rd of December 2025, Counsel for the Governor raised a preliminary objection to the hearing of the proposed removal from office by impeachment of Honorable Amos Kimwumi Nyaribo on the following grounds: that the impeachment motion dated 11th of November 2025 failed to attain the constitutional and statutory threshold, and that therefore the purported resolution for removal of the governor by way of impeachment was invalid and incompetent, as it failed to meet the mandatory threshold under Article 181 of the Constitution and Section 33 of the County Governments Act, and B, that the concept of proxy voting was alien, illegal, and null and void, and the attempt to explain the discrepancy through proxy voting was legally untenable and compounds the illegality of the proceedings premised on acts of fraud, forgery, and misrepresentation. Now, honorable senators, in urging the Senate to find that the threshold of 2/3 of all members of the County Assembly in support of the impeachment motion was not achieved, Counsel Elias Mutuma for the Governor stated that the County Assembly of Nyamira comprises 35 members, and that therefore the requisite 2/3 majority for a valid impeachment resolution was 24 members of the County Assembly. Council further submitted that the official record of the sitting of the County Assembly held on 25th of November 2025 confirmed that only 19 members were physically present in the Assembly chamber. Council stated that despite this, the Assembly recorded 23 votes in favor of the motion, and that this was numerically impossible, and that to him, this demonstrated that improper and fraudulent voting had occurred. Now, Counsel for the Governor submitted that the phrase, all the members of the County Assembly in Section 33(2) of the County Governments Act is not ambiguous and refers to the total composition of the County Assembly as established under Article 177 of the Constitution and as gazetted by the Independent Electoral and Boundaries Commission after the 2022 general elections. Now, Council contended that as a membership of the Nyamira County Assembly is 35 members, and as 2/3 of 35 is 23.33, this can only be rounded off to 24 members. Now, Council further submitted that the County Assembly's argument that the 3 vacancies in the Assembly reduce all the members, end quote, from 35 to 32 was legally flawed and absurd. Council therefore urged that for these reasons, the impeachment proceedings before the Senate could not proceed and required to be terminated at the preliminary stage. Now, Counsel for the County Assembly took a different view on this matter. The thrust of the argument in response to the first preliminary issue was that the Independent Electoral and Boundaries Commission, IEBC, in Gazette number 9956 of 2022, published on 24th August 2022, set out the names of the elected members of the Nyamira County Assembly, and further that this was not the limit or absolute number of members who were required to sit in the Assembly at any given time. Council further noted that when the Constitution and the County Governments Act imposed the requirement of 2/3, this could only refer to 2/3 of the members present at any particular time. According to the Council, an alternative interpretation would mean that no activity could go on should there be a vacancy or a challenge in filling the vacancy, and further, that any business that has been transacted by the County Assembly of Nyamira on the basis of the members of the County Assembly of Nyamira at the time will be null and void. Council further stated that this issue is a question of fact that ought to be determined through the examination of evidence during hearing. On the second limb, on the second limb of the preliminary objection relating to voting by proxy by the 4 members of the County Assembly, Counsel for the Governor stated that this was alien to the County Assembly procedures, illegal and null and void. Counsel further stated that no authority was granted by any member to vote on their behalf by proxy, and that the 4 members of the County Assembly in whose names proxy votes were recorded had provided sworn statements confirming that they were neither present in the Assembly nor did they issue an authority, written or otherwise, for any members to vote on their behalf. In this regard, Counsel for the Governor referred to the Standing Order 67 of the Nyamira County Assembly Standing Orders, which requires the decision of the Assembly be made by members present and voting. Counsel argued that the act of proxy voting was expressly prohibited and was a nullity as it contravened Standing Order 67 of the Nyamira County Standing Orders and the principles of representative democracy. It was Council's case that the unauthorized casting of votes in the names of absent members without the authority constituted fraudulent misrepresentation, forgery, and impersonation, further vitiating the entire process. As such, the Governor takes the view that the maximum number of voting MCAs would have been 19 MCAs. The Governor concludes that the required statutory threshold of 24 members of the County Assembly to support the motion was not achieved. In response, Counsel for the County Assembly stated that the delegation of voting by proxy was carried out in a right manner, and further that the proxy letters were available as evidence of the said delegation. Now, in support of this submission, Counsel referred to the case of Mukisa Biscuit Manufacturing Company Limited versus West End Distributors 1969 EA page 696, which set out the threshold for a preliminary objection. In particular, Counsel stated that the issues raised and in question, that is the number of persons who voted, was a contested fact that ought not to be argued at the preliminary stage. He further stated that although the Governor's Council had indicated that there was evidence of affidavits sworn by 4 members of the County Assembly, averring that they did not delegate such authority, the County Assembly would, at the hearing, provide evidence of mobile telephone and email communication to counter this allegation. It was therefore not possible for the Senate to make a determination on the matter at the preliminary stage without hearing evidence on the matter. Now, Counsel further argued that although proxy voting was not expressly provided for in the standing orders, the Speaker of the Nyamira County Assembly had exercised the discretion provided for Standing Order 1 of the Nyamira County Assembly Standing Orders to allow for the proxy voting. He further stated that although the standing orders were silent in expressly providing for proxy voting, this did not bar the use of proxy voting in the Assembly. Now, Honorable Senators, following the oral submissions on the preliminary objection and the responses, Senator Edwin Sifuna, Senator Enoch Wambua, and Senator Boni Halwale sought various clarifications from Council, including on the relationship between provisions of the Constitution on vacation of office by members of parliament or county assemblies vis-a-vis the provisions of law as that set out threshold for voting on a matter, at what point the membership of a county assembly is determined after election, or whether this is a moving target, and whether it will not be prudent to give the county assembly the opportunity to adduce evidence on the matters raised in the preliminary objection in the main hearing. Subsequently, the respective council gave the responses to the questions and clarifications sought by honorable senators. Arising from the preliminary issues canvassed, the following are the issues that require determination by the Senate. 1, whether the preliminary objection raised qualifies as a preliminary objection, properly so called, and whether, therefore, its determination must precede the further progress of the current impeachment process. And 2, if the answer to the first issue is in the affirmative, then whether the 2/3 threshold required for voting on the impeachment motion of the County Assembly was met. Now, honorable senators, I shall commence with the first question, which is whether the preliminary objection raised qualifies as a preliminary objection properly so called, and whether, therefore, its determination must precede the further progress of the current impeachment process. As you will recall, the Senate has previously been confronted with this question in previous impeachment proceedings. The question of what constitutes a preliminary objection was well set out in the leading case of Mukisa Biscuit Manufacturing Company Limited versus West End Distributors. And this is what, in that matter, the court held. A preliminary objection consists of a point of law which has been pleaded or which arises by clear implication out of the pleadings, and which, if argued as a preliminary point, may dispose of the suit. Examples are on the objection to the jurisdiction of the court, or a plea of the limitation or submission that the parties are bound by contract giving rise to the suit to refer the dispute to arbitration. A preliminary objection raises a pure point of law, which is argued on the assumption that all facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained, or if what is sought is the exercise of judicial discretion. Now, honorable senators, in light of this similar decision, it is now well settled and established in our practice that a preliminary objection does not require evidence to be adduced as proof of its existence. It is limited to points of law and cannot be raised if a fact has to be ascertained by the use of evidence to be adduced. Reference has been variously made by counsel for the governor and counsel for the county assembly to the jurisprudence that has been laid down by this House in the two Kericho impeachment matters, now commonly referred to as Kericho 1 and Kericho 2, in which the Senate arrived at different conclusions on the nature of preliminary objection and the appropriate place at which to make a determination. In fact, there was no contradiction in the determinations made by this House in Kericho 1 and Kericho 2. In Kericho 1, the Senate determined that a classical preliminary objection was one which is purely on a matter of law and which required no evidence to be adduced for its determination. In that case, it was not in contention that the number of county assembly members who had voted in support of the impeachment motion was 31. It was also not in contention that the total number of Kericho County Assembly members was 47. The only question was whether 31 members constituted the 2/3 threshold as required by law. In Kericho 2, on the other hand, the question was whether some of the County Assembly members alleged to have voted in support of the motion did actually vote. This was a matter requiring evidence to be adduced, including the examination and cross-examination of the said county assembly members, and accordingly, this was not a matter that could be determined at a preliminary level without hearing the evidence. Kericho 2 was therefore ruled to belong to the second category of preliminary objection that can only be reasonably subsumed in the full hearing, but for which a determination by the Senate would have to be made at the end before the proceedings to vote on the charges. The question, therefore, is whether the current preliminary objection belongs to the jurisprudence of Kericho 1 or Kericho 2. Now, honorable senators, in the current impeachment proceedings, It is not in contention that there were 19 members in the County Assembly of Nyamira present and voting at the time of impeachment. Secondly, although there is contestation about the validity of the votes purportedly cast by proxy by another 4 members, there is no contestation that the total number of members who voted did not exceed 23 members. The County Assembly, by its own admission, has submitted a list of 23 members as having supported the impeachment. The governor's side, on the other hand, object to this impeachment on the basis that the correct threshold should have been 24 members rather than any lesser number. What is in contention, therefore, is whether the threshold of members required to have voted in the matter is 24 or 23 or lesser number. What is additionally in contention is whether in reckoning the 2/3 threshold, the number of members of the County Assembly is to be applied as 35 or 32. The legal question in contention is whether the number of legislators of the County Assembly remains fixed and unaffected by any vacancies for the purposes of reckoning thresholds, or whether, as Councillor Katwa Keegan for the County Assembly argues, it is a moving target that cannot be reckoned in advance and depends on the membership of the Assembly at a particular time, having subtracted any vacancies existing. Now, honourable senators will appreciate that this is a constitutional and legal questions of the most fundamental ramifications, the decision on which reverberate far and wide and well beyond Nyamira County Assembly, and possibly including this chamber, where at various times and for various reasons we have had vacancies. The decision the Senate takes on this legal question will no doubt bind us going forward in the manner in which we reckon delegations for purposes of voting when there are vacancies in the Senate. From this perspective, it is clear to me that even though a number of matters of fact were raised by the County Assembly in their preliminary objections and fundamental legal questions of threshold and whether the correct number of delegations that were required to impeach the governor of Nyamira County at the time of the impeachment was undertaken was 24 or 23 or any lesser number is a pure question of law whose determination by the Senate is necessary before these proceedings can continue. This is a preliminary objection of Kericho 1 typology. Honorable Senators, this legal question goes to the substratum of the impeachment proceedings and has the prospect of terminating the proceedings at this point. Accordingly, and as I've guided from this chair before, this kind of preliminary objection raised by the governor requires to be determined by a vote of the Senate, which is the trial court in the impeachment matters. It also obviates the need to answer the second question on whether the threshold was met. As this is what will be the subject of the vote. Now, the manner of proceedings to this vote will be a motion, moved in the usual manner after notice of motion has been given. Debate will ensue in the usual manner, and the vote will be taken upon the conclusion of debate. To this end, honorable senators, I have directed the clerk of the Senate to prepare and circulate a supplementary order paper containing a notice of motion and the motion limited to the preliminary objection on the threshold that was required for this impeachment. Now, honorable senators, the decision on the proposed removal from office by impeachment of the county governor and any consequential or incidental decision thereto are matters concerning counties, as has been previously ruled in all impeachment processes undertaken by the Senate. These decisions are made by the Senate by vote, by county delegations. Accordingly, the preliminary issue will be upheld only if it's supported by votes of at least 24 delegations. If the preliminary issue is upheld, this impeachment shall terminate forthwith. If, however, the preliminary objection issue is negated, the Senate will proceed to the main hearing of the impeachment proceedings. It is so ordered. Thank you, honorable senators. So, honorable senators, you'll be provided with the supplementary order paper that is going to guide us in the proceedings for the afternoon. Order, honorable senators, please let us take our seats. Honorable senators, let us settle down. Senator Osotsi. The minority leader, kindly take your seat. You know, honorable senators, I want to believe that all of you now have the supplementary order paper. That is the one that is going to guide us. Can Senator Omtata be supplied with the supplementary order paper, please? Senator Onyonka, Senator Fatuma Dulo, Senator Enoch, Senator Hamida, Senator Olekina, it's also in your iPads. In the event that you don't have the physical copy, you can get a soft copy in your iPads before you. Clerk, you may proceed to call the next order.
Order number 2, notice of motion.
The Senate Majority Leader.
Thank you, Mr. Speaker. Mr. Speaker, I rise to give notice of the following motion, which is a preliminary objection by the Governor of Nyamira County on the threshold applied for the proposed removal from office by impeachment of the Governor of Nyamira County. Oh, sorry. Allow me to take it again, Mr. Speaker. This is notice of motion for preliminary objection by the Governor of Nyamira County on the threshold applied for the proposed removal from office by impeachment of the Governor of Nyamira County by the County Assembly. Aware that pursuant to Article 181 of the Constitution and Section 33 of the County Governments Act 2012, on Tuesday the 25th of November 2025, the County Assembly of Nyamira approved a motion for the removal from office by impeachment of Honorable Amos Kimomi Nyaribo, the Governor of Nyamira County, noting that by letter reference SPK/CAN/1/2025 dated 25th November 2025 and received in the office of the Speaker of the Senate on the 26th of November 2025, the Senate of the approval of the motion by the County Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly, including the list of the 23 members of the County Assembly that voted in favor of the removal from office by impeachment of Governor of Nyamira County. Further noting that one of the preliminary objections raised by Honorable Amos Nyaribo, the Governor of Nyaribo County, was a requisite what did I say? Sorry, Nyamira County. Nyamira County was a requisite threshold for passage of a motion for the removal of governor from office by impeachment, being 2/3 of the members of the County Assembly, as provided for in Section 33 of the County Governments Act and Standing Order 62 of the Standing Orders of the County Assembly of Nyamira, is 24 members of the County Assembly and was not met. Now, therefore, the Senate resolves to uphold the preliminary objection that the threshold required for the removal of a governor from office by impeachment contemplated in Section 33 of the County Governments Act and Standing Order number 62 of the County Assembly of Nyamira was not met, and forthwith terminates the hearing of the proposed removal from office by impeachment of Honorable Amos Kimomi Nyaribo, the Governor of Nyamira County.
Next order.
Order number 3, motion, preliminary objection by the Governor of Nyamira County on the threshold applied for the proposed removal from office by impeachment of the Governor of Nyamira County by the County Assembly.
The Senate Majority Leader.
Mr. Speaker, I rise to move the following motion. This is a preliminary objection by the Governor of Nyamira County on the threshold applied for the proposed removal from office by impeachment of the Governor of Nyamira County by the County Assembly. That, aware that pursuant to Article 181 of the Constitution and Section 33 of the County Governments Act 2012, on Tuesday, the 25th of November 2025, the County Assembly of Nyamira approved a motion for the removal from office by impeachment of Honorable Amos Kimomi Nyaribo, the Governor of Nyamira County, noting that by letter reference SPK/CAN/1/2025, dated 25th November 2025, and received in the office of the Speaker of the Senate on the 26th of November 2025, the Speaker of the County Assembly of Nyamira informed the Speaker of the Senate of the approval of the motion by the County Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly, including the list of 23 members of the County Assembly that voted in favor of the removal from office by impeachment of the Governor of Nyamira County, further noting that one of the preliminary objections raised by Honorable Amos Kimomi Nyaribo, the Governor of Nyamira County, was a requisite threshold for passage of a motion for the removal of a governor from office by impeachment, being 2/3 of the members of the County Assembly, as provided for in Section 33 of the County Governments Act and Standing Order 62 of the Standing Orders of the County Assembly of Nyamira, is 24 of the members of the County Assembly and was not met. Now, therefore, the Senate resolves to uphold the preliminary objection that the threshold required for removal of a governor from office by impeachment contemplated in Section 33 of the County Governments Act and Standing Order number 62 of the County Assembly of Nyamira was not met, and forthwith terminates the hearing on the proceedings on the proposed removal from office by impeachment of Honorable Amos Kimomi Nyaribo, the Governor of Nyamira County. Mr. Speaker, let me first take time to explain what this motion means. We must celebrate the Senate for how refined our process have become over time. Previously, Mr. Speaker, when we have been faced before this session, by previously I mean before this current Senate, the 13th Parliament, we previously had similar situations where a county assembly will come before the Senate and they'd argue that we have impeached our